Hello and welcome back to our Legal Aid Fair 2023. My name is Tamisha Powell and I will be your moderator and facilitator for the session this afternoon, where we'll be talking about the Road Traffic Act, the changes to the Road Traffic Act, and our presenter this afternoon, or yes, this morning, will be Dr. Garth Lyttle, who is an esteemed attorney at law and really needs no introduction, but I will still attempt to do one. Dr. Lyttle. Dr. Lyttle is a graduate of the University of the West Indies 4 times over, having been awarded his LLB in 1979. He's a graduate of the Norman Manley Law School and received his CLE and was called in 1981. He has a postgraduate degree in public administration. He has an executive master's in business administration, and he's also a doctor. He attended, the Dr. Mount Olive Bible Institute and Seminary in 2015 and has an honorary doctorate in divinity from that same institution. He is the president of the Seventh-day Adventist Lawyers Advocate Association and has tutored at the University of the West Indies in constitutional law for 4 years. He has been in private practice for upwards of 41 years and has been a notary public since 2000. He's currently the president of the Notaries Public Society of Jamaica, and he's held that position since 2022. And so welcome, Dr. Lyttle. We are very, very happy to have you, and we're looking forward to what you'll be talking with us about this afternoon. It's very on topic, something that is really on the cusp of everybody's mind. With Dr. Lyttle is Mrs. Renee Malcolm Robinson of Council, and we're very happy to have Mrs. Malcolm Robinson with us this afternoon as well, or this morning as well. I keep saying afternoon, this morning as well. So thank you, and I now turn over to you, Dr. Lyttle.
Thank you, Madam, and it is indeed my high honor and pleasure to be with you on this occasion and to be the first person to give a lecture on road traffic matters. It is very topical at the moment, and I would wish that persons who have questions to ask would hold those questions until the end of this lecture, and then you can direct your questions to the chat. Okay. Today I wish to look at the Road Traffic Act. I have there 1938 to 2023. 1938, there were very few motor vehicles around. And so there was no need for our parliament to legislate on this matter. But we, as a country, an overseas country from England, by reception, we adopted the Road Traffic Act from the United Kingdom. The first Road Traffic Act was promulgated in 1938 and copied from Britain and received by way of reception. We never had the capacity in those days in our parliament to prepare something like that, so it is just adopted from England. And in addition to the act, there is a book which is known as Stone's Justice Manual. This book, it carries both the statute law and the case laws, and is used by most English-speaking countries, the parliament, as a guide in framing legislation, and the courts find it useful in interpretation, particularly in understanding definitions and concepts of road traffic law. The definitions are set out in the Act. In section 2 of the Act. And in particular, I just wish to deal with one. The question, what is or where is a road? The road is defined as any roadway declared to be a road pursuant to the provision of subsection 2 of the Road Traffic Act. What is the significance of this? If the place is not a road, then the police cannot prosecute or successfully prosecute a person who is deemed to have committed an offense at that particular place. So the first must establish that a place is indeed a road before they can properly prosecute one. But isn't it a case where that is happening today? The place must be gazetted or declared by the portfolio minister as a road. And I would wish you to remember that, because you're young lawyers and you will be dealing with these matters out there from time to time. I have as my note here that Spencer James Drive in the middle of Halfway Tree has not been gazetted and therefore not a road. I've had many prosecutions annulled as the place where the person was prosecuted was Spencer James Drive, and it is not a road. I now turn to the question of the documents pertaining to your motor vehicle, and you will soon see the real significance of this. The certificate of fitness is the first one. When the vehicle is driven off the wharf, next place you have to go is to the traffic examination department, and they will examine your vehicle and issue to you a certificate of fitness for the motor vehicle. Once this is done, it is deemed to be fit to be on the road. The traffic examiner is seen to be the expert on motor vehicle fitness matters, and that is without question. The function of the certifying officer, therefore, is to examine the vehicle, and once he passes it, then that is it. It is passed and fit. Under section 10, subsection 2, the traffic authority may at any time examine any motor vehicle and issue to that motor vehicle or revoke the certificate of fitness in respect of that motor vehicle. The defect must first be remedied. Then you return to the examiner who will be examining your vehicle for the second time around and certifying it that it is fit. Then he will issue to you the registration certificate. It bears the data, I beg your pardon, the registration certificate bears the data of the owner of the vehicle and the motor vehicle itself. Then you have the insurance certificate. The insurance certificate is from a private source, but the law so requires that you should have insurance coverage over your vehicle at all times. The license disc on the front windscreen of your vehicle, please note, it carries an L letter and some numbers behind it. That L takes the police right into the government record. So once they plug in those numbers and the letter in their computer, they'll be able to see whether or not the vehicle is licensed. Then there is a registration plate. This is important because it identifies the vehicle on the road. And if it is a PPV unit, then you will see the PPV plate, which is red in color. Oh, the PPV means public passenger vehicle. So it is licensed to carry passengers, and that is stipulated, I beg pardon. Now, you will find, if you closely examine these documents, that your motor vehicle is the most regulated private property that a person can ever own. Look at all the documents pertaining to it. And each of them, when stopped on the road, you're asked to produce these documents to the constable who stopped you. Of importance to you too, as young lawyers, the distinction between trailer and an articulated vehicle. Very important. The trailer under section 11(1)(g), and you have the articulated vehicle under 11(2), section 11(2). Under section 11(2), the articulated vehicle, it is that the part to the back of it is superimposed and attached to the front of the vehicle. I repeat, the back is superimposed and attached to the vehicle. The front of the vehicle is called the tractor head, and it bears a part of the weight that it is carrying. The trailer is pulled by the unit in front and bears no weight. So nobody can be prosecuted in respect of the trailer because the trailer is pulled by the front vehicle. And the trailer bears all the weight that it is asked to carry. Under section 14(4), a person shall not be convicted if he proves that he was on his way to having his vehicle examined. You know, there are times when your vehicle, the certificate is up and you're late, but you're able to get the relevant receipt issued by the tax department. And once you're on your way to the examination, the law says that you should not be prosecuted in that process. License of drivers. You have the license to drive a motor vehicle. The learner, driver. One is now required to do a formal test before he or she is issued with a learner's license. I repeat, for the learner's license, you're required to do a formal test before you're issued with such a license. If a learner is driving without a learner's license, both the learner and the licensed driver who is sitting beside the learner will be prosecuted. The learner driving without a learner's license and the licensed driver aids and abets that person to drive without a driver's license. I don't know if sometimes you pass on the street, some back street, and see somebody is giving another person a side steer or a drive off the vehicle. This is what intended to cover that. So the learner must be issued with a learner's license. And the person who is competent to drive and sitting in the passenger seat, that person must also have a license. Just to remind you of something, under section 16.4, it deals with driver's license and 3 categories: private driver's license, the general driver's license, and your motorcycle license. One must be 17 years of age before the learner will be issued with a learner's license. You must be 18 years old before the private license will be issued to you. Section 20, subsection 1A, an invalid can be issued with a driver's license. Let me back up a little. The general driver's license does not afford you to drive a motorcycle. And please note the word I use, drive, because we tend to say we ride, but it is driving. Once it has an engine and you have to go on the vehicle and drive, then it is drive, you're driving and not riding. The pillion is a rider because the pillion is not in control. So the learner and the person accompanying the learner, driver, must possess driver's license. A general driver's license cannot cover you to drive a motorcycle. I've already dealt with that. The charge is driving a motorcycle without a license. It stands to reason that you cannot use a motorcycle license to drive a 4-wheel vehicle. If you wish to have a motorcycle license, though you are well and fully qualified to drive a 4-wheel vehicle, you have to go to the examination depot and drive for it, and you'll be issued a motorcycle driver's license. And neither can the motorcycle license be used to drive the 4-wheel vehicle. Now, here's a very contentious area: the production of driver's license to a constable. Section 22 of the Act. If you're required to produce your driver's license to a constable, formerly you had 5 days within which to do so before being prosecuted. Now, to drive without a driver's license in your possession is an offense, a prosecutable offense. The result: the vehicle will be seized and you will be charged with driving a motor vehicle without a driver's license. That is in the Act, section 22 of the Act, which speaks to the driver's license. Here's a very interesting area, which I'm sure you have been waiting anxiously for me to deal with. Conviction driving offenses or conviction for any offense whatsoever. The effect of suspension, when you're convicted, the effect of suspension, by operation of law, the order which is made by the court suspending you from holding or obtaining a driver's license. If you drive whilst disqualified, the law says you are to be sentenced to imprisonment for a period of 6 months. I repeat, once you are disqualified from holding or obtaining a driver's license, the law says you are to be sentenced to a term of imprisonment for 6 months. There's just one narrow exception. What is that exception? You are to know the exception if you're dealing with your client and your client is in such a predicament. Application to lift the disqualification. Application to lift disqualification. Now, whilst you're disqualified, the law also allows you to apply for the disqualification to be lifted. And it is not a simple thing. Can you imagine a man who finds himself in such a predicament? He has a house and mortgage which ought to be paid every month. He has his children going to school. He has general maintenance of his family and his business. And he, for whatever the reason might be, he loses his license. 6 months is a long time, long time. But the law says that he can apply only after the expiration of 6 months before his application can even be considered. If you apply for a license during the period of disqualification, and you apply for the license in, let us say, in Lucy in Hanover, and you are granted that new license, that license would have been obtained fraudulently. I repeat, if a court suspends your driver's license and you get smart and you go to Lucy in Hanover or Montego Bay and apply, and being the competent driver that you are, you're issued with a driver's license there. The law says that you would have fraudulently obtained a driver's license, and the punishment for which is 6 months imprisonment. So don't let that happen to you or any of your clients. Under Section 26, we now deal with the question of speeding. Under Section 26 to 16 to 20, between 16 and 20 miles, I beg your pardon, we're now dealing with the mileage or miles. The fine for exceeding the speed limit by 16 to 20 is $2,000, and you would have accumulated 2 points. 21 to 30, the fine is, this is category 2 now, and this fine is $4,000 and 4 points. 31 and over, it's 6 points. Under $6,000, I beg your pardon, under the new act, the regulations deal with the question of fines. The starting point will be 16 to 30 miles, I beg your pardon, would be $6,000. That's a starting point in the court. And it goes to a height of $15,000. So where the first one ends, the new act or the regulations begin. Section 15.1. On renewal of your application or an attempt to renew your driver's license, if there is a fixed penalty in respect of the commission of the offense, your license will not be renewed. In other words, if you have outstanding tickets, the tax department is going to simply say to you, please go and deal with those matters because you have so many outstanding tickets. In other words, a red flag comes up on your name and your application, and you will not be granted the license or allowed to renew your license unless you go to court and clear the tickets. How unfortunate. At least 1 year waiting period for your case to be tried. So when you put it into the balance, what it is saying is that go and pay for your ticket and come back to us. These offenses are offenses that fall under what is called a second schedule offenses. You must have a driver's license or a permit. It is an offense to hold a driver's license and apply for another. I've already dealt with this, but it is worth repeating. On the section 62, on the section 22, you ought to supply a medical report which will say that you're a fit and proper person because you have been medically examined and you're fit and proper to hold a driver's license. Certain kind of diseases or disability is indeed a barrier to your being granted a driver's license. Learner license, the learner driver, you will also see that you are not to be under the influence of alcohol or any sort of influence for you to get a license. The learner driver is 0.10% or 10 micrograms of alcohol per 100 milliliters of breath. In other words, if you are a learner or even a mature driver and you are found with driving a motor vehicle under the influence, you'll notice that for the learner, the standard is lower. But for the driver on a whole, once you're found driving a motor vehicle and you're under the influence, it is a charge. And I can tell you from the top of my head that such a situation, it carries 14 demerit points and you'll be automatically suspended for 1 year. The bottom line is you ought not to be drinking and driving. Neither the instructor nor the learner should be driving under the influence of drinks or drugs while driving on the road. Under the new act, find that it specifically make driving and smoking ganja an offense. And of interest, it also says, or if you are in charge of a motor vehicle. How do you deal with that? You can be driving and you feel to smoke. And you get out of the car and you go on the bank and you're there smoking the weed. You're in charge of the vehicle. And so you can still be charged by the police by being in charge of a motor vehicle and found smoking ganja. Go now to the demerit point system. Under section 32, where a person accumulates 20 demerit points, then you will be suspended from holding or obtaining a driver's license. And this suspension will be by the Traffic Area Authority. The Traffic Authority, it has the power to regulate motor vehicles on the road. And may I just point out to you that the police forms one part. The responsibility does not fall on the police alone. The Traffic Area Authority has that responsibility, the primary responsibility for regulating motor vehicles on the road. If you are suspended by the Traffic Area Authority, you have to be retested when you apply for the return of your license. The length of time for you to be suspended by the Traffic Area Authority is 1 year. Section 34, 7 and 6 One must pass the test before applying for reinstatement. So if you don't wish to have to go through the formalities of a test again, then you need to ensure that your slate remain clean. And your application would only be entertained by the traffic authority after the expiration of 12 months. There's no in between. Under section 36, you're disqualified. If you're disqualified by the court, the person can apply to the court 6 months after the disqualification order is made by the court. Now, let me indicate something here. Once you're disqualified by the court, the law says after 6 months, you must apply before the same judge who disqualified you, or not, or perhaps the same court, because the judge might be changed. So you have to go back and face the same judge or the same court in respect of your disqualification. The persons who can apply after 6 months of disqualification to lift the order, the judge will consider. Now, these are very, very important areas. The judge will consider the character of the person who is standing before him, the conduct of a person during disqualification, the nature of the offense. And you see some lovely letters there. Let me read them for you. The nature of the offense that which you were disqualified for: dangerous driving, reckless driving, or careless driving, driving under the influence, to manslaughter, or causing death by dangerous driving will not be helpful to the client's case. I'm putting the client right in your office now. So when a client comes to you, you are going to inquire as to the background as to why the person was disqualified by the court. And you list these: dangerous driving, reckless driving, careless driving, or driving under the influence. Or worse yet, if you were convicted of motor manslaughter or causing death by dangerous driving, will not be helpful to your case. In other words, you need not even apply. As counsels to be, your application, your client's application ought to be based on hardship. That is what the law says. In that hardship, you would spell out the number of children going to school and the parents who are living with you and so on and so forth. But it would be an affidavit which you have to put together and to impress the court as to why your disqualification should be lifted. Eating, very interesting area. Fines. Speed limit. Those are things which you will come across on the road, but perhaps you might not have paid much attention to them. These constitute a part of the rules of the road. Section 46 of the Road Traffic Authority of the Road Traffic Act. The Road Traffic Authority may restrict or prohibit the use of any part of the road. Under Section 47(2), the Road Authority may cause or permit traffic signs to be placed on or near a road. Let me pause here to say something on the Section 46 stipulation. The authorities may restrict or prohibit the use of any part of the road. I don't know if you, my listeners, if you will recall, There was a time when the Mandela Highway, a part of it, was cordoned off for buses, JUTC buses running from Caymanas, come right into, I think it is 6 miles. And some people from the taxi association, they were aggrieved. And having been aggrieved, they went to court, and the court said, no. The authority has the power to permit traffic to operate on a particular area, and in particular, if it is a temporary thing. So remember this, the police has the power to set up a road sign to direct traffic to go to the right or to the left, as the case might be. And that power for the police would be under the Constabulary Force Act. Section 57(1) says driver or rider to obey all traffic signs. Stop light, stop signs which may be lawfully placed, erected or exhibited on or near any road so as to be visible from a distance. Anyone who contravenes such sign commits an offense. Now the sign is planted on the road, right? And you disobey it, and it has a money figure attached to it. In other words, all traffic signs ought to be obeyed because they give directions to you as a motorist. And disobedience of it will land you in court if the officer is nearby, because he must be in view. Thank you. Section 52, there is a presumption that in the absence of evidence, all signs are deemed to be lawfully erected. This word, deemed to be, a term of art, but it is for the judge. Once the judge is satisfied by the evidence given by the officer that the sign is there and the driver disobeyed the sign, the judge is going to deem that the sign was lawfully erected. If you have evidence to rebut that, then you may produce that evidence. But the sign which is standing there is cloaked by a deeming provision in law. And the judge is going to say, yes, it is deemed to be lawfully erected. And so you decide whether you plead guilty or go for trial. So there is a deeming provision that runs with each sign that you see on the road. Here's of some interest. The marking on the road is classified as sign. That means the white line that is in the middle of the road. I repeat, the white line that is in the middle of the road is deemed to be a sign. It is not standing, but it is lying on the road and in the middle of the road for your guidance, but is deemed in law to be a sign. The unbroken white line is also a sign, and it means something. The bar below the traffic light overhead, and there's a white line before you at which you should stop. And that is called a bar. And it accompanies a stop sign or a stop light, as the case might be. Remember, it is also a traffic sign. What is the standing of emergency vehicles? The driver of an emergency vehicle in the performance of his duty may disregard the direction of a traffic sign. It's worth repeating. The driver of an emergency vehicle in the performance of his duty may disregard the direction of a traffic sign. Shall the driver, though he is authorized in law in an emergency situation, he must pay due regard to the safety of other traffic and other persons, other users of that road. This means that the driver owes a duty of care to the users of the road, even in an emergency. This is what the law says. It says that he must pay due regard to other vehicles and persons on the road. This means that the common law duty of care is preserved. So even though he's driving in an emergency situation, he has a duty to take care. That is blank. Okay, what is before me now? I think we have already touched on it, but no harm in repeating. The suspension period, 10 or more points give you 6 months suspension, 14 points or more, but less than 20 give you 1 year suspension. 20 or more points, 2 years suspension. It seems to me that from the law, the 2 year suspension is a limit for the resident magistrate to impose that limit or abide by that limit by the law. My reading of the law somewhere else says that a Supreme Court judge has the power to suspend a person beyond the 2 years limit. What do you think? I now move to a very contentious area on the road, but it's an area which as councils you ought to know, and because you'll be dealing with them. And may I just indicate to young councils, when you go to the rural areas, try and do very well in this particular area, because this is an area where you might be able to earn your keep. First, you have the stage carriage license. Secondly, the express license, then the contract carriage, the hackney carriage, route taxi, and robot. I point out to you that robot is not a license. The vehicle that is classified as a robot is unlicensed. And so in effect, what we have are 5 categories of public passenger vehicles. We're going to look at them individually because it is so important that we should. Motor vehicle carrying passengers for hire or reward at separate fares, we call that the stage carriage. It has the power to stop and pick up passengers at any point, pick them up and set them down along the line of route. Now, those are the 2 words used by the law. And I just pause to give you my own experience in this regard. Time, persons who are licensed to go from, let us say, Kingston to St. Mary or Portland, they would stop at a corporate area bus stops and pick up passengers, and they would be prosecuted for operating in the metropolitan area. When I go to court, I simply say that the law says that the person who is driving has the power to stop and pick up and set down passengers along the line of route. And that has to stand, because it did not say, but not in the KMTR, that's a Kingston and St. Andrew corporate area. Once you understand what is meant by the line of route, then you can understand, for leaving downtown Kingston to St. Mary, the person who is going to St. Mary or Portland is not concerned about a bus stop. The person wants to get on the bus, and it says along the line of route. And that always prevails in court. See, on such a license, the term rural stage, that means it is not to operate in the corporate area, but indeed to drive out of the corporate area to the rural area, and from the rural area back to the corporate area. The contract carriage, this is motor vehicle carrying passengers for hire or reward as a whole, or for an agreed price or fixed rate. What this simply means is that the vehicle would pick up the person perhaps at his gate and would take the person from there to the designated point. He ought not to pick up another passenger in between, because the vehicle on a whole is hired out to the person who is sitting in it with the driver. I think that one is quite simple. The hackney carriage. The carriage carried passengers for hire or reward or as a whole on any thoroughfare or place frequented by the public, with accommodation for not more than 5 persons, including the driver. There's a rich history associated with this. And you say I put 4/5 passengers. Many years ago, the carriage drivers were being prosecuted left, right, and center for carrying 4 passengers plus him or herself as a driver. When I go to court and I raise this issue, and eventually the judge always agrees. But then you find over time, judges change. And persons are still prosecuted for having 5 persons in the vehicle, including the driver. But under the act, it simply says that the driver is a steerman. So the driver is specifically identified as a person who is in charge of the vehicle, who holds the steering. And so you would have the driver plus 4 persons. When one of the matters came up, I took the matter to the Supreme Court and asked for a declaration among several declarations. Among the declarations that I asked for was that the hackney carriage license allows a person to have 4 passengers plus the driver. And so before the matter actually reached before a judge, the then Minister of Transport, he rushed to Parliament and had the act amended. And so the act now reads 5 persons, including the driver. I don't want you to miss the point. My position was that the driver plus 4 persons, that would give you 5. So the new amendment now shows that there ought to be 5 persons, including the driver. What's the difference? Who won that one, that round? Very interesting observation. Under Section 221 of 2005 amendment, the power to seize motor vehicles came about. The stage carriage, if it operates as express carriage, route taxi operating off its route, licensed hackney carriage, if the hackney carriage is engaged in any other pursuit under any other law, then the power is there to seize it. The vehicle is seized. Now that is where you as counsel comes in. My suggestion to you is that once your client comes to you and report that to you, the first thing you do is to write to whether the transport authority or the police and make a formal demand for the return of your vehicle, your client's vehicle. When that is done, you would have set the stage for you to sue on your client's behalf in detinue and or conversion. Because let me tell you, it is one of the most difficult things for the police or the transport authority to prove any one of those offenses that are stated there. Now, interestingly, the man who is running the robot, if he says to you, no, I was not operating my vehicle contrary to the Road Traffic Act, I was not running my vehicle as a robot, the law makes provision for that. 5 things that you're to look for when you're interviewing your client. 1, motor vehicle. 2, passengers. 3, journey. 4, consideration. And 5, separate payments. Now, let me start with the separate payments. If all 4 persons in the vehicle and everybody will be paying the driver of separate payments, then you're operating the vehicle. The person will be operating the vehicle as a hackney carriage. The consideration, you have to look for that. The journey, the police must also know the journey. And the passengers must be there to give a statement to the police. And of course, you have the information about the motor vehicle. When all of that is gone through, and assuming that there's a trial and the judge is satisfied, here it comes again, the deeming provision. Once the judge is satisfied that all of those, 1, 2, 3, 4, 5 are satisfied, then the judge has now the power to deem that the vehicle was operating contrary because it had no road license and it was so operating. There are 2 interesting cases, and counsels, I would wish you make a note of these. R.V. Edwards, Section 63, sub 3 of the Road Traffic Act, and R.V. Russell, Section 63, sub 3 of the Road Traffic Act. Just to give you a gist of what these 2 cases are about. The persons concerned were charged with operating their motor vehicle without a road license. Both instances. And in both instances, 1966 cases. And they were convicted in the first instance court, and they went to court of appeal and also lost. But here I have them down as locus classicus cases. Yes, they are, because Section 60, subsection 3, deals with the very same things here. And if the prosecution can establish the 5 principles there, then the prosecution would win. If the prosecution cannot establish more than 2 or 3, then it is the the defendant who would win his case. All 5 principles must be established for the judge to deem the vehicle as carrying passengers for a higher reward without a road license. Oh, the deeming provision is a provision which is a tool of the judge once the judge is satisfied that enough evidence before the court to establish that the vehicle is operating contrary. Under section 78 of the old act, you will find the same thing in the new act. It says that the vehicles carrying commercial load must be licensed as a commercial carrier. I ask you to look for 2 provisos under this section. Proviso number 1. If it is being used to carry goods for others, then the commercial license is needed. The owner driving a private vehicle with his own goods need no license. Where the owner is driving his private vehicle with his own goods, he need no license. That's proviso number 1. Proviso number 2 says where the servant and or agent is driving his master's vehicle, carrying goods for his master's business, then he needs no commercial license. It is important because from time to time you find people being stopped by the police and having seen the goods inside, they're charged with operating without a road license. But then such a case would require that the police would have to prove that the goods inside are being carried for someone else and that the person who is the driver was also charging or has charged that person to convey the goods to his premises. So remember, under section 78 of the Road Traffic Act, the owner of the vehicle conveying his own goods in his own vehicle need not have a license, a commercial carrier's license. Neither should the servant who is conveying the goods for his master be required to have a license. We have already been through this, but I'm going to take you to a point, and I would wish you appreciate these documents once again. The certificate of fitness, registration certificate, insurance certificate, and you have the registration plate and road license if it's a PPV unit. There is a situation, I'm going to take you back. One offense which is very popular these days, but a popular offense requires a popular defense. If, and this is an actual case I'm going to be citing to you, if a person is charged under section 46 of the Road Traffic Act with operating his vehicle with a fraudulent plate, Here's a person who has all his documents together, but what his vehicle is wearing is a red plate, which he just acquired. Now, a very careful policeman, an astute policeman, having seen the plate and it looks very new, brand new, it is up to the police to stop the person and inquire. And when the person says, these are my documents, I acquired the plates legitimately, and the policeman contacts the traffic area that records the existence of road license and the plates on vehicles. When they contact that department, the department says, no, that vehicle ought to be wearing this plate and not that plate. Guess what? So the police would charge the person for the fraudulent use of the registration plate which it is wearing, which is a PPV. I repeat, the charge is a fraudulent use of the registration plate, and so the vehicle will be seized and the registration plate seized, and the police would charge the person and put the person before the court. Now, as counsels, don't just take this case and defend it. You have to manage this case. I'm going to give you an example how you are to deal with this particular situation. Manage the process. Things to do. Under Section 46 of the Road Traffic Act, it says fraudulent use of. In other words, the person now being charged with fraudulent use of the red plate. The prosecution holding all the documents. The first thing that you ought to do is you obtain copies of the same papers that are in the hands of the prosecutors, the police and the clerk of the courts. Then you serve a notice of intention to tender into evidence the same documents. You will soon see the wisdom of that. And having served that notice of intention to tender the same documents, the certificate of fitness issued by the examiner for the said vehicle, the receipt from the tax office for monies paid for the red plate. If the vehicle is seized and you apply for it to be released on bond so as to preserve your position to sue indebting and conversion for the loss of earnings, because you're quite satisfied that your client obtained his PPV plates legitimately. So you go through all the steps and you send them your demand letter so as to preserve your position. Then when it comes on to the trial now, what you need to do, you take the first leap. You apply to the judge for leave to make your submissions in limine. And I'm sure by the time you finish your submissions, the prosecution would see the light of the day. And the judge would adjourn the matter, rightly so, to study your submissions. Because at the end of the day, what triggered the charge, what triggered the circumstance leading up to the charge is the fact that the road license issued by the Transport Authority, the certificate of fitness issued by the examiner, the receipt from the tax office for the money, the vehicle was seized. So guess what? The position is this, is that at the end of the day, it is the persons in the tax office who would not have handed over the necessary information to the registry that records every motor vehicle that is in the island and the corresponding registration plate. So this is why I use the term that you need to manage the process. And when you do all of that and you make your point in limine, I am sure the judge will simply say, like I did one not too long ago, and when the clerk was holding out that there ought to be a trial, the judge simply said you cannot try a half crime. And the matter was thrown out. That's the purpose of your managing the case. It is fraud. The charge is fraudulent. And in such a situation, you need to know your stuff. And this is why the documents that we put forward earlier, I'm going to go back to them. The certificate of fitness issued by the traffic examiner, the registration certificate issued by the tax office, the insurance is a private contract between yourself and the owner, sorry, between yourself and the insurance company, and the registration plate which you have purchased legitimately, the road license, if it's a PPV. Now, this one is issued by the Transport Authority, and the road license would carry the registration plate, letters and numbers. The registration plate, sorry, the registration, well, the plate is there. The insurance certificate would carry the registration plate, letters and numbers. The registration certificate would carry all the data about the driver and the vehicle, and it would carry also the registration letters and numbers. And the certificate of fitness would also carry the registration letters and numbers. So you sew up your case and you deal with it, because when you make your point in limine, these are the documents that you go through and you show. And I'm sure no wise judge would ever allow that matter to proceed any further. So I think I've indicated that you manage this case. That's it? Okay, we are now at the end of this first lecture, and the floor is now open for questions, and you're asked to direct your questions to the chat. And I'll just take a short break, and on my return, I'm prepared to answer the questions that you have.
Okay, thank you, Dr. Lyttle.
You're welcome. All right.
Madam Chair, you may proceed with any questions.
Okay, all right. So our first question is concerning CC plates. And the question says, if my friends came to help me move, does that mean they would require a CC license based on the narrow definition that was given?
As long as the person who turns up to help is not charging money for carrying the load, then that person would need no license.
Okay. All right, thank you. Right, I'm just going to check the chat to see if we
Yes.
have any more questions at this time. Although your presentation was so thorough, the process, or perhaps we're having a situation where no one is having any, or it requires any clarification. So I'm not seeing any questions in the chat at this time. So we just like to remind our participants that if you have any questions based on the presentation we were just listening to from Dr. Lyttle, you should type your questions in the chat, and I will be more than happy to read them aloud so that Dr. Lyttle can address them for you. Dr. Lyttle, I have a question while we wait. I know while you were doing the presentation, you indicated that the renewal of your license can be hampered or prevented if you have any outstanding tickets, and the time period for a court application is about a year. You'll have a 1-year waiting period. My question is there any way to apply for that application to be expedited? I know we discussed the circumstances for the disqualification to be reduced, but I don't know if we could shorten the time to apply in like manner.
If to shorten the time, if you relent, you go to court and you plead guilty, then the time is shortened. But why should you plead guilty when you know you're not guilty? And I'm saying this about a year because it will take about that time for your matter to be tried. And while you're waiting for it to be tried, then time is running against you. And it's unfair. You must be given the opportunity to defend your cause in court. Yes.
Thank you. Thank you very much, Dr. Lyttle.
Well, could I just make one addition?
Yes.
Please remember, there is no extra time given to you with your driver's license, or the only time which you have 1 month, what do you call it again? A period of grace is in respect of the license on the vehicle. The period of grace runs for 1 month from the last date when the license shows that it is to run. There's no grace period on your driver's license. There's no grace period on the certificate of fitness. There's no grace period on anything except the licensing of the vehicle. And why is it so? Because you still have to pay for it.
Right.
Yes.
Right. Right. I have another question here, Dr. Lyttle. Based on the presentation with regards to road, and that the offenses with regards to the Road Traffic Act have to occur on a road, the question is, how do we determine where is a road? Is there a list? Is there some database that can be checked to confirm where a road starts or ends here in Jamaica?
When you go to court and you simply say to the judge, the place I was prosecuted was not a road, and you're asking the court to produce the Gazette, the Government of Jamaica Gazette, which shows that that place was a road. If they can't produce it, then out goes your case, which would be in your favor, of course.
Right.
Because the law distinctly says that it ought to be on a road. Now, I have one little difficulty because I must bring it to your attention. The new act with the question of road, it has quite a few areas. And the last one says, or anywhere that a motor vehicle, oh yes, it's here. It just permit me a little to read this for you. Any main road under the Main Road Act or parochial road under the Parochial Road Act. A bridge, a culvert, any other roadway or thoroughfare declared by to be a major road. And the last one says, any road or thoroughfare to which the public has access by means of a vehicle. Now, this cannot be the position of the law anywhere that you have access by use of a vehicle, because a man can have his own private property.
Right.
And the police ought not to be on his private property. There's an ancient saying which says that there are places that the king's writ does not run. And if you have your private property and you have your vehicle on it, the police ought not to be there to interfere with your vehicle. To the extent that, and the new act also recognizes it, that if you own a vast amount of lands, half of the road on this side belongs to you. And what if the other side also belongs to you? So both sides of the road belong to you. You need not have a licensed vehicle to drive on that road. That is the position of the law. Once the road falls in an area which is your land on both sides, then you need not have a license to drive your vehicle on that road. It's a common law position, but it is preserved by the act. Yes.
That's very interesting.
Quite interesting.
Okay. We have another question here. The question says, what about the airport? I was once told I could be arrested for stopping in front of the police station at the airport.
Not for stopping. The airport has its own set of regulations. And this is why if you were to be found parking in an area and you're prosecuted and you go before the court, the fine is much higher than if you had parked on the roadway. So, you know, there's a new set of regulation governing the road at the airport, I think, for both airports.
Okay. This is a follow-up question to that question. It says, if you stop to drop someone off and there is a no parking sign, is the stopping a breach of the no parking sign?
Well, parking means stop long enough and the engine is off.
Okay.
That is what parkings mean. Parking rather means. Yes.
So once the engine is still on and I'm not there for any length of time, I'm not parked.
You're not parked.
Grateful. All right. I'm not seeing any more questions. So at this time, Dr. Lyttle, Mrs. Malcolm Robinson, I'd like to introduce Miss Hope Brathwaite, which is one of our year 2 students, just to issue the vote of thanks on our behalf for your presentation.
Good afternoon. Are you hearing me?
Very loud and clear.
Thank you. Good afternoon, Dr. Lyttle.
Good afternoon.
And on behalf of the administrative staff and students of the Norman Manley Law School, I would like to take this opportunity to thank you for taking the time to be here today, delivering a beautifully presented and informative session on the changes to the Road Traffic Act, and also highlighting the distinction between the 5 different types of road licenses, the difference between the trailer and the articulated, trailer, the observing traffic signs, the necessary documents necessary to operate on our roads, and even the popular offense of using fraudulent plates, and of course, giving us your sage advice. The information imparted was indeed important to us, especially both to us as young attorneys and to the young drivers among us. We are cognizant of the fact that, it's the easiest way to end up in conflict with the law or even in prison is through driving a motor vehicle or operating a vehicle.
That is correct.
This session will certainly keep us on our toes and on the straight and narrow. And again, I thank you.
You're welcome. It is a pleasure, my pleasure. And I'm happy to participate in this, your grand occasion, which marks the 75th anniversary of the University of the West Indies. And you notice I'm wearing my tie. Though I bought it about 10 years ago, it's the first I'm wearing it.
Yes, and Dr. Lyttle, of course, it's also the 50th year anniversary of the Norman Manley Law School.
Yes.
So yes, very significant period for both
Right.
the law school as well as University of the West Indies. So yes, thank you very much, Ms. Brathwaite, for the vote of thanks. And we also want to thank our participants and our subscribers for tuning in. We want to just remind you that our next broadcast will commence at 2 p.m. And if you'd like any further information with regards to the services that we provide here at the Norman Manley Law School Legal Aid Clinic, you can visit our website at nmls.edu.jm, or you can email us at nmls.lac@uemona.edu.jm. And we also have a WhatsApp number, 876-561-9803. We'd be more than happy to assist you and just to give you any further information that you may require. So at this time, we're going to be signing off for a little until 2 p.m. where we'll have our next session and we'll have Dr. Lyttle with us again to go in a little bit more depth with regards to offenses with regards to the Road Traffic Act. So we'll see you at 2 p.m. Thank you.